They lead the way in the law so many times. And I'm sure you're all familiar with referendums in California, right? Californians get to vote on all kinds of stuff. Whether or not marijuana should be legal, they get to vote. Whether or not to raise taxes, they get to vote. You know, they vote on all kinds of stuff over there. And sometimes that can be a real problem. In California, there's a coalition of people who have been pushing to increase consumer rights on data. And in 2017 and leading into 18, they had a lot of support statewide for a referendum that was going to go on California's ballot that would have given 8 new rights under the law for individuals about our data. How businesses collect it, how they manage it, how they use it, how they disclose it, sell it, all of that. So the challenge with referendums in California is if a law becomes law through the referendum process, the only way to amend the law is through referendum. Okay? So if you can imagine trying to amend a law like that through a referendum process, it would be a nightmare, it would never happen. So in order to cut off that referendum process at the pass, the California General Assembly, literally over the course of a weekend, cobbled together the California Consumer Privacy Act. And in the space of like 72 hours, they wrote this like beast of a law, passed it, sent it to the governor for his signature in order to like short circuit the referendum process so that the referendum didn't go on the ballot. And their goal in doing that was, if it was a law passed by the General Assembly, then the General Assembly can come back and amend it. So the goal was to actually prevent the referendum from happening so that the General Assembly would hold the power of whatever amendments needed to happen. It all happened so fast. Everybody's head was spinning over this, and there were literally typos all through the bill that had been put forward that they voted on. So some of the amendments that they've had to pass to clean it up were literally like fixing typos, and people would go back and read a clause and they're like, we thought we knew what that meant when we wrote it, but 6 months later we read it again and we don't know what that means. So from the minute they passed the CCPA, all the lawyers working in data privacy and security are like, oh, we don't know what this means. So California has been busy amending it this year in their legislative session. And the legislative session just wrapped up in mid-October, so whatever amendments have been put in now are going to govern. So we'll see kind of what the final form of it looks like here very soon. But here's what it essentially means for you. First of all, yes, it may apply to you. Even if you're not a California business, if you have clients or customers in California, it may apply to you. There are 3 factors to determine whether or not it applies, and the threshold is pretty low. So, like, if you have a website that has cookies and you collect information and people in California access your website and use your website, it may very well apply to you. I mean, there's a whole test and all that stuff. I'll spare you the details, but it's entirely possible that it applies to you. If you are a business, one test is very clear-cut. If your business annual gross revenue is 25 million or more, and you have customers in California, it applies to you. So that's one takeaway. Now, it created 8 new legal rights for Californians. Things like Californians now have a right to know what PI businesses collect on them. And they can send in a request to a business and say, I want to know what you have collected on me, and I want to know where you store it, how you store it, and who you sell it to. And by the way, the definition of sell is exchanging that information for anything of value. So even if your primary business isn't selling data, even if you're not a data broker, if you take a Californian's personal data and exchange it for anything of value, then under the law in California, that's a sale of that data. So under the law in California also, PI is very broadly defined. Anything that could identify a particular individual or a household is PI. So your cell phone pinging on a tower here, whatever code that generates to the tower would be your PI. Yeah. The ISP address of your internet server at home is your PI. Your purchase history on Amazon is your PI. Okay? All of that is PI. So from a consumer standpoint, the advocates for consumer privacy are pretty excited about this law. And the goal, ultimately, is to create a federal level regime around this kind of privacy right for individuals. Now, that all creates obligations on business. Businesses have to be ready to tell people what data they've collected on them, how they're storing it. Is it encrypted, not encrypted? You know, how are you using it? Who do you disclose it to? All of that. California's Constitution also has a right to privacy written into the Constitution. And so this law, plus California's constitutional law on right to privacy, could actually create what's called a private right of action, which means that you, as an individual, could sue my business over my use of your data. So we have a bit of a wild, wild west. It's not quite clear what the California law is going to mean. It goes into effect January 1st. Enforcement begins July 1st of next year. And here's a fun little tidbit. The Attorney General is tasked with enforcing the law from California. California's Attorney General, that is. And the Attorney General's office in California gets, I believe, last I checked, 20% of whatever fines they generate by enforcing the law. So the law has embedded in it a pretty powerful incentive for the Attorney General's office to be aggressive in their enforcement.